just to establish that your work has been read by these justices and seems to have had some impact here. Now, can you get a little bit more into what Barrett said, into her concurrence, and what you think that might mean for the balance of the court on Second Amendment cases going forward?
Yeah, sure. So your listeners don't need any background on what the majority said, but just to recap it so I can put her comments in context. So the majority's decision, as I read it in Rahimi, is really narrow. Essentially, the court says there's this one historical principle, and that historical principle fits basically 922G8C1 and maybe some other laws, but not a ton of other laws. It doesn't say that's the only historical principle it finds, but it says, like, we found this historical principle. You can disarm people who have shown to be a credible threat to the physical safety of others after a judicial finding. Right. So it's a really narrow historical principle. Exactly. Yeah. And I think part of the very narrowness of the majority's decision is that there's 8 justices that signed on to it. They don't all agree about the scope of what set of historical principles might justify other laws. So we've got a lot of concurrences. I counted 7 different justices out of the 9 justices who wrote separately, who wrote something in the Rahimi decision. And one of those concurrences was Justice Barrett's. I think the thrust of her concurrence was to say later tradition can't change the original meaning of the constitutional text, and only the original meaning controls. So even if we found a later tradition that was, widespread and it was widely seen to be constitutional, if it's a later tradition, it can't trump the original public meaning. But in the course of doing that, she also fleshes out these ways to understand what the original public meaning is. And she rejects this reading of Bruen that would say, if you don't find specific laws, that means it's unconstitutional today. Instead, she adopts kind of this principles-based approach to looking at what she calls original history or original contours. And she says we have to look at the evidence of what kind of principles they would have understood the Second Amendment to be consistent with, not try to find particular laws. Sometimes those laws can shed light on those principles, and sometimes those regulations are what give rise to the principles. But we look for the principles. We don't look for particular regulations.
Yeah, and it is interesting in the context of some of your critiques of Bruen here, because it feels like, especially with her concurrence and Kavanaugh, and the majority opinion itself, that the conservatives outside of Thomas, and we'll get to Thomas in a little bit, because I feel like you might have a similar view of his, of how this might all come out, or what it does to Bruen. But the other conservatives on the court seem to be more in this idea of that you don't need a historical twin. It feels like she's kind of saying you don't need to have literal restraining orders at the founding for the restraining orders that affected Rahimi to be constitutional today. She's not necessarily saying you don't need any sort of evidence that this was that this type of act would have been appropriate under the Second Amendment. You just don't need a literal exact copy of the law. That, this is one of the main issues that they argue about in Bruen over and over again, right? Throughout the concurrences, at least, is this concept of, like, we haven't given a lot of answers on, because they set this standard of you don't need a historical twin, but also this isn't a regulatory blank check. And so you're supposed to fall somewhere in the middle of that. And it feels like they're going to just need a lot of time to go through and flesh out this test.
She says you don't even need a cousin. It doesn't have to be a cousin. So no, we don't need twins. We don't need cousins. But yes, regulatory blank check is on the bad side, and we're kind of trying to figure out where we are.
Yeah. And so what was your main takeaway from the majority opinion in the case? It sounds like you think it was pretty narrow. What impacts do you think it's going to have on those lower courts?
Yeah. So I thought it was significant that it was an 8-1 decision. I thought after argument, most of us who heard argument thought the government was going to win. And the question was, what was the margin of victory that the government was going to have in that case? Was it going to be 9-0? Was it going to be 8-1? Was it going to be 7-2? The fact that Justice Alito and Justice Gorsuch signed on to the opinion, I think was significant. The fact that Justice Thomas did not, though, and that he was the author of Bruen, I think really suggests some internal grappling of the justices who themselves signed on to the Bruen decision about just how that test was supposed to work, how that opinion was supposed to be understood. So I got from the majority's opinion that they really didn't want to give, or maybe they couldn't with 8 justice majority, give a lot of guidance for other kinds of cases going forward. Although they wanted to correct a few of the errors that lower courts have been making after Bruen. One of those is to demand too much specificity in the historical record, to try to find too close a match for historical regulations. They said the Fifth Circuit did that wrong. They seem to suggest that lower courts were misunderstanding that. And then relevant, I think, to this case and maybe a few others, they talked about the standard for facial challenges and how the Fifth Circuit misunderstood or misapplied the standard for facial challenges, which requires the challenger to show that this law is unconstitutional in all of its applications, as opposed to maybe permissibly constitutional in some applications, even if there are other applications that might be problematic. So those are the things that fall to the Fifth Circuit for. Maybe some of those have broader echoes, but I think for me, I was maybe a little bit surprised at how narrow the decision was, especially because the court acknowledges lower courts misunderstanding Bruen. I thought we'd get a little bit more guideposts on how to address at least other questions related to permissible disarmament schemes, and particularly the other challenges that the court has already pending for the felon in possession cases. And beyond the kind of principles-based approach, namely telling courts to look to historical principles and not require exact matches to historical regulations, beyond that, I'm not sure how much guidance it gives to resolving felon in possession cases. And so I could see, for instance, if the court was to say vacate and remand the pending petitions in those cases, the 922G1 cases, I could see each of the courts that have split already on this question issuing basically the same opinions again and saying, like, we don't think Rahimi calls into question our reasoning. Their reasoning, of course, is the exact opposite, but I could see each of those courts reaching the exact same decisions even under Rahimi.